Well, hello everyone. My name is Przemyslaw Walasek. I'm attorney at law. I'm the head of IP and IT department in the law firm Taylor Weston and WC in Warsaw. And I've got the opportunity to talk with you a while about the legal issues for game developers. And well, I know that the perception of the lawyers may vary, and the lawyers are not the ones which are very liked among the entrepreneurs due to the fact that actually they are very often being perceived as business breakers, as a source of problems. And well, partially it is true because we are naturally focused on the risks and on the problems. Sometimes it happens that we solve them, but usually we manage them, and sometimes the solution is very, very, very difficult to find. And many entrepreneurs at the beginning of their adventure with business, I mean, any internet startups or any startups dealing with any new technologies do not like lawyers due to the fact that actually they bring some of the awareness about the risk, about the problems they do, and that can really, work as an obstacle due to the fact that actually ignorance is bliss, and if we do not know the risk, we are able to dare things which we wouldn't normally do if we know what can happen. And partially it's true that we may cause some problems, but on the other hand, I mean, having the awareness of the risks and the dangers ahead of you is a value in itself. Sometimes it's good to know what can happen if something goes bad, wrong. So I think that such awareness is good to have. So that's how I perceive my role tonight. I mean, to shed some light on legal issues which may be relevant for game developers. And I will start with very simple questions. I don't know if you can see that in the last rows. Not really. Simple questions, but the answers are usually very challenging. I mean, the first question is what is a video game, and we know more or less what we are talking about, and we know that what type of the product is it. But I would like to make an attempt to define what a video game is, but from the legal point of view, and how a lawyer would perceive a video game. And if we know already what we are talking about, then the next question would be, is it, protected from legal point of view? Is there any legal protection which can be granted to such product as a video game? And if so, what type of legal protection is it? I mean, who can be protected, to what extent, under which circumstances, and which prerequisites needs to be fulfilled to enjoy such privilege of being legally protected? And the last thing is the flip side of this coin. Actually, when we create something which can be protected, mostly as a copyrightable work, we need to remember that actually, the others are protected in the same way. And it's only natural that we are inspired. We are not living on a desert island. So actually, we are creating something new. But naturally, everything what is created is being supported by ideas and works of other people. And the most crucial question is, how can I get inspired in a safe way? In a safe way in the legal meaning of that word. Meaning that actually, how can I be inspired about infringing copyrights of other people or other exclusive rights? Because it doesn't have to be necessarily copyright, really. So, and I would like to start with the first question. Talking about the video game. How to define the video game from the legal point of view? And if a lawyer looks at the video game, he looks at these elements. All these parts, which can be legally protected. So there are many components, and the product as such, video game, may be very complex and sophisticated and complicated, and there are many layers of this legal protection. The first element is the software, which is the most obvious one. Software as such is indispensable in each video game, and of course it can be protected, and that's I would say the core of the video game. And there is another dimension. That's the user interface. This soft part of this product. That part which is being perceived by the user. And there are many elements on the second dimension which may be protected not as a software, but as a traditional copyrightable works. So first of all, graphics, which is, pretty obvious. Soundtrack, soundtrack, it may be a song. So actually there are also many people which may be involved as authors enjoying the protection under the Polish copyright law. The author of the lyrics, of the music, the artist. Documents, manuals, but also documentation relating to the software as such. Documentation of technical nature. Dialogues, also the author of the dialogues, but also the artist performing the dialogues. The story, which is also a very, the plot, which is also a very, very important part of many games. Not all of the games, but role-playing games, for example, as such, and story, and also the title, which also may enjoy some legal protection. And these elements are generally being protected as copyrightable works. And there are also other elements. The brand, which could be the same as the title, which may be protected as a trademark. So not as a copyrightable work, but as a brand which is registered by the relevant authorities. Know-how. The know-how meaning the knowledge which is made confidential and is protected against being disclosed in an illegal way, and also a database. So actually the product as such is very complex, and that's also the reason for which the proper classification of the video game as a copyrightable work is very difficult for the lawyers. There are many attempts made in the legal doctrine trying to classify, to determine what type of a work it is, because there are certain types of the work being protected under copyright law. The general ones like literary works, music and so on, but also special types of copyrightable works like software, which enjoy a bit specific, type of legal protection, which is a bit different from the general protection of copyrightable works. And for example, audiovisual works, which also have a set of specific provisions in our Polish Act on copyright law. So this classification is not purely a theoretical dilemma, but just a practical problem which needs to be solved in order to know how to protect the video game in practice. And generally, the answer to that question is that actually there is no such category in the Polish Act, on the Polish copyright law, which would fit, to the category of the video game. So actually, the representatives of legal doctrine, not the judges, because in Poland we don't have any relevant, significant judgments on this topic, but the academics are arguing that actually a video game needs to be perceived as a sort of a special type of the copyrightable work, being a multimedia product. So the multimedia work, in fact. And there are also different types which would fit that category, different types of work, but video games could be one of them. So that's the answer to the first question, at least an attempt to answer the first question. And maybe I'll say something also about the idea of copyright protection as such. You see the prerequisites which needs to be fulfilled in order to get that protection, to have that protection. And the point is that actually one of these prerequisites, the creation of an individual character, is very subtle and is very hard to determine, to demonstrate, to verify. And that's one of the most difficult challenges of the copyright law, and not only of the Polish law, but generally in the world. In the Western legislations, actually it's hard to determine, hard to draw a specific borderline between these works which are protected as copyrightable works and those which, are too simple, are not sufficiently creative to be protected under the copyright law. And the point is that actually no one knows how to solve this problem? I mean, usually, instinctively we think that actually there is something which goes beyond the knowledge of a regular judge or the lawyer, attorney at law, because, well, this question, is not the question relating to legal issues. Legal issue, really. In terms of that, actually, it relates to the prerequisite, legal prerequisite of copyright protection. It relates to the legal issue, but as such, it requires a bit more knowledge and experience than the knowledge referring only to the provisions of law and knowledge referring to how the law operates in practice. And normally, in that situation, a judge, which would face that problem, would appoint an expert, which would, familiarize himself or herself with the case and with the background of the case, and would provide his opinion or her opinion on that particular issue, saying actually whether it is copyrightable work or not, whether it is creative or not. But the point is that actually there are no such experts available, and actually in practice this issue needs to be determined by the lawyers, by the judge. And that's one of the main reasons of that problem. Actually, we do not know how to assess that particular, very, very particular and very important prerequisites. And in practice, it works like that. Actually, there is this term of the copyrightable work is understood very broadly, and the interpretation is quite liberal. And many works which we would normally wouldn't believe that actually they should be protected as a copyrightable work, in practice enjoy such protection. For example, culinary recipe sometimes can be also protected by copyright law, which is maybe a bit surprising. Maybe not those which are the public domain, which we know already for years, but very original ones. The other example are the pictures, the photographs which we do. Most of them are not copyrightable works, and we kind of know it and we feel it. Actually, they are just simple pictures we made. Everyone can make a picture without any effort whatsoever. But well, in the practice in cases being determined by the courts, the picture as such, are perceived as a copyrightable works. So actually, there is sort of a preassumption that actually everything which, at the first impression, could potentially be copyrightable work is, regarded as such by the judges in case of any legal disputes. And actually, it's the job of the other party being, accused or being sued by the plaintiff to prove the judge and the other party wrong. So that's how it, works in the practice. And there is also no minimum creativity threshold. There is no criteria which we could, measure the creativity, which would be helpful in this respect. And the one further, important issue in this respect is actually that part which is protected. That's the expression. So we have got the dichotomy between the idea and expression, and ideas are not protected as such. Some claim that actually the ideas do not have any value. Some argue that actually it's quite the opposite. It's the idea which is the most valuable thing in every copyrightable work. But, well, from legal point of view, the ideas are not protected whatsoever, because that would be to disadvantages for everyone, actually. So actually, it's this process will need one step further. We need this idea being implemented. So we need the expression of this idea, which in sort of, not in a tangible medium, but it needs to be expressed in a way which can be perceived by the others. So for example, if you would take a poem as a copyrightable work, I could now, take a minute and invent, made up a poem and say it aloud. And that will be then a process of, creating a copyrightable work, because saying it to you will be, well, example of establishment of that copyrightable work. So until the moment when it's my head, it's not copyrightable work. But at the moment when I'm saying it to you, it becomes the work which is being protected by law.
May I ask you a question?
Yeah, of course.
if I've got an idea for a game, and it's based on a story, so until I write or say the story to you, it's not.
Yeah, that's a very interesting point, because I'm going to talk about this. I mean, later on, but we can address this issue at this moment as well, because as I said, it is the expression which matters, you know. So actually, when you write it down, it is the expression, not the story itself, but the expression. I mean, the text you wrote will be protected as a copyrightable work, and you may be right asking, what about the plot? I mean, the plot as such may be very creative and may have a value. I mean, the characters, the world which is described by the author. And, well, that's a very interesting issue. Usually, well, it depends on the type of the activity we are assessing. If someone takes your plot and implements it in its own or her computer game, then we have to then decide whether we do have here an example of the copyright infringement. It depends on the extent of this, to what extent is this your plot being used in this other computer game. If someone took the whole plot, all the characters, in every detail out, generally it is believed that actually there is a clear copyright infringement. But let's imagine actually someone is developing the plot you invented and make, you know, a sequel or the prequel, whatever. I mean, takes the characters from your plot. There is usually, of course, everything depends on the circumstances of the case, but usually there is no copyright infringement in terms of copyrights, but there may be infringement of the personal author's rights. So actually the infringement of these rights which are based on this very personal link between the author and his work. Because in this case, I mean, most likely it is the integrity of the work which is being, you know, infringed. So that's how it is. And as I mentioned, I mean, the software enjoy a bit, I mean, specific legal protection. It's difficult to. That's one of the most important parts of every video game, an indispensable one. And but well, which is only one of the components, one of the elements. It would be wrong to, you know, to reduce the video game to the software only. And I guess that's pretty obvious for everyone. Because, as I said, it's not only the software, the engine, which is used as a part of the video game, but also, you know, this user interface, which sometimes is very important, sometimes very decisive even for commercial success. Software are protected as literary works, and we've got a specific set of provisions in our Polish Act. I mean, dealing only with the software, and that's the result of implementation of the software directive. So that's why this protection of the software is regulated at the level of European Union, and we have implemented just similar like the other European countries, and we have implemented this solution to our act. One important thing about the copyright protection is to know that actually this protection is limited, not limited, but actually is based on the exploitation fields. So actually, my work is protected only to the extent of the existing exploitation fields. If the technology will develop, and let's imagine such a situation that actually I have invented a video game, and let's assume that actually that's a multi-product, multimedia work, and I'm selling all the rights to the producer, I mean, to the investor, whoever, I mean, and he's buying all the copyrights. All the copyrights to the video game I have invented, to all the existing exploitation fields. And let's assume that actually after 10 years or after 5 years, I mean, the technology has developed so much that actually there is another existing exploitation field. And it means that actually these rights, this bunch of all the rights connected to my video game, which I invented a couple of years ago, which I transferred to the other entity, is not complete. I mean, in terms of this transfer, actually, I haven't transferred all the rights because first of all, I wasn't able to transfer the rights to the exploitation fields which did not exist at that time. And the second thing is that actually I do have as an author, I mean personal rights, personal author's rights, and they are not transferable. So actually it's good to remember that actually you are not able to buy everything from an author. So actually there is always something left, and there are ways, you know, to address these issues in agreement. They are not perfect, so there's always sort of a link between the author and the work, even if the author is, you know, one of many employees at a huge corporation, and the corporation is, you know, buying all the copyrights of their employees. One interesting thing about the software, I mean, being protected as a copyrightable works, is the compilation, which cannot be usually done by the others, and that's quite interesting thing due to the fact that actually usually familiarizing yourself with the work is not an example of the infringement of the copyrights. So if you are, you know, listening to the music or reading a book, you are not violating any copyrights whatsoever, because that's simply not possible. I mean, you need to do something more to infringe third parties' copyrights. You need to reproduce, you need to sell, you need to make it available on internet. That's how the copyrights are being infringed. And if you are just, you know, analyzing the work, that's not an example of any copyrights infringement. That's how it works in general. But in case of the software, it's a bit different, you know. There is such the compilation ban, and generally the others are not allowed to analyze, to decompile, to do the reverse engineering in order to get to the source code. So that's one thing which is quite, I mean, particular and specific about the computer programs. There are certain limitations to the every exclusive rights. That applies also to the copyrights. And one of these limitations is the private fair use, which is not applicable to the software. And there are many, you know, examples of public fair use. For example, the libraries may use copyrights, or for example, they may be used for the purpose of parody. I mean, these are the situations where, well, the monopoly of the copywriter is limited, of the author is limited, and these, I mean, limitations are limited in terms of this to the software. Actually, software is not so protected as in certain respects as the other general works. And yeah.
Are there any other areas where the compilation ban works? For example, for pharmacy or something, or software is the only?
No, that's the only situation I know, because that wouldn't be, I guess, sensible to. Because I mean, the compilation needs to refer to the source code. So actually, it.
Yeah, I mean more like reverse engineering. For example, if you make the medicine into the.
I see. Well, that's something different.
Process to
yeah.
How it works.
Yeah, that's something different, you know. Yeah, that there is such a compilation, but I mean, we use it only with regards to the source code. So actually, there is, you could say that there is sort of, you know, equivalent for the medicines, but that's a whole, I mean, different story, because that's the patent protection and the copyright protection. So actually, that's a bit different regime. I mean, law regime, legal regime, applying to the medicines and medical products. Yeah, and the next, well, thing which is quite crucial, I mean, for the game developers, and very practical one, which may be quite interesting for you, because I guess that we had also, I have also addressed some, I mean, theoretical issues which may not be so interesting, but here it comes something practical, is the question, who is the author, you know? And if you are, that's a good question, you know, if you are creating anything, it's the question, if you are creating alone, I mean, there is no question at all, you know. It's only you who is an author, who can be classified as an author. But let's imagine that you are collaborating with someone else on whatever basis. I mean, whether you do have an agreement or not, or you are collaborating, within a sort of, formalized organization like a company, limited liability company, whatever. Then, the question is who has the copyrights? I mean, whether me as an author, or the company, or the other people which were involved, and so on. So actually, that is, quite crucial, because specifically, I mean, for internet startups who very often, at the beginning of their adventure with the business, are collaborating with many people without having any formal agreement. And that may be a very practical issue, because sometimes it happens that actually the young people invent something very, very promising in terms of the commercial success and the prospects for commercial success, and then it transpires, or it turns out actually someone else has the copyrights. For example, actually not that the group of these internet startup people are not the only ones which are enjoying the protection, because there was someone else who did something, who provided a creative contribution and is also protected as the author. So there are different categories. So we've got the joint authorship, we've got the collective work. We may invent a video game, and we can do it alone with a couple of friends, but we can also buy some copyrightable works, for example, soundtrack or a plot or a graphic from someone else, and that would be, and put it together, creating a collective work. And the other question is the software produced by the employees. I mean, that's the most clear, situation, a very clear situation, and in terms of identifying the person who enjoyed the copyright. Because if you have a company which is the employer, employs, for example, the game developers, or if you are a game developers hired by a company, then the copyright to the software you create is owned by the company, not by you. So generally, it is the software of the company, not yours. You've got some limited rights to the software. I mean, in terms of your personal author's rights to the computer program, but as such, it is the producer, the company, who enjoy legal protection. And the next issue is the issue of indirect authorship. Let's imagine that actually you create software or a computer program which is producing copyrightable works. And the question is, whatever, paintings or any graphics or music. It's possible, actually. You may create a tool which is, producing something of a great value, in terms of the creativity, and which can enjoy the legal protection. And then the question is, who is the author? Is it a machine? The software? The computer program? Or just the person who is, the author of the software? And the answer is, of course, it can all be a human. So actually, it is, the human who wrote the software, who created the software, is also the author, indirect author of the results of operation of that software, which also may be perceived as a copyrightable works.
Can I have a question? Yeah. Right in this one. So if somebody creates something like that's automated when it comes to making music, graphics, whatever, but it needs some randomization from the user, to see it or anything, is the user who provided the random numbers needed to create this automated work also an author of this indirect authorshipy?
Yeah, absolutely. It depends who is providing the creative contribution.
But there is no creative contribution. It's just like a seed. You need to generate something. You just type in the seed number, and then it's not creative. It's random.
I see. Okay. It depends on the involvement. It depends on the involvement of the user. If the user is doing something, which also would fulfill this general prerequisites, of having this legal protection. Actually, we absolutely have, user as an author, and the question is whether we have a collective work, or whether we have, example of co-authorship. That would be the question to decide. Knowing all the circumstances. If there was a common, a joint intent, between the user and the provider of the software, because it is also possible, you know. Actually, we create a video game which is very interactive, in which is based on this interaction, and which requires this creative contribution from the users. And this is the part of the game, you know. That actually, you should be creative and you should provide creative input. So that will be this joint input, and as a result, we would have a joint. Not really indirect. Well, partially indirect. Well, it depends. It would depend on the operation. It could be indirect or direct, depending on the operation of the software. So, but actually, it will be joint authorship. And if it's, you know, if we weren't able to find this common intent, actually that would be collective work rather. But all the individuals who provided this creative contribution would be protected as authors. Absolutely. Yeah, and you know, there's one interesting phenomenon which is called, copyright crisis, and it is a permanent situation. I mean, the copyright law is in a permanent crisis, which results from the fact that actually the new technologies are developing so fast. I mean, so fast that actually no lawmaker. It applies to all the lawmakers, not only to the Polish lawmaker, which is very, you know, always late, and which is not so, you know, speedy with creating new law. But the point is that actually the copyright is always too late. And I mean the solutions which we have, the tools we have, are not adequate to the problems which we need to face. And one of these examples of this copyright crisis is the concept of the exhaustion of the copyright. And this concept is based on the consideration that actually once you sell your copyrightable work as a copy, you exhaust your rights through this act. So if someone is buying legally a copyrightable work, its copy, actually can sell it further without, you know, exposing itself or herself or himself to the risk of infringing anyone's rights. And all believe that actually that concept of exhaustion of the copyright applies only to the tangible copies. I mean, copies understood as, you know, physically existing objects, you know, like a book or like a CD and so on. And it meant that actually if you are selling anything, you know, online, you do not exhaust your copyrights. So you are in constant control of the copyrights. It was quite absurd, you know, due to the fact that actually you are changing the medium, you know, instead of selling the things on tangible medium, you are selling it online. And we've got quite, different results, from a legal point of view. In one situation, we do have the exhaustion of rights, and such copy can be sold, further without any limitations, or with certain limitations, but nevertheless, as a rule, can be sold further. And if you are buying online, then actually it means that actually you are still, you know, not able to sell it further to other people. Until, you know, the judgment of European Court of Justice, who said that actually, the economic results of this change of the model of the distribution are still the same. You know, if you are selling, you know, it traditionally, the result is more or less the same if you are selling just the digital copy of the software together with a license, which is perpetual and which cannot be terminated, and for which you pay a price which is, corresponding to the price of the copyrightable work as such. So actually, the court decided that actually we should perceive the situation as the example of the exhaustion of the copyright works. So actually, it was sort of, example of a very dynamic interpretation of law, which is, not perfect, but actually the court, the European Court of Justice was very innovative and dared to deliver such very, maybe controversial but very, innovative judgment, extending this concept also on every online transaction. So it means that actually if you are a game developer and you are deciding to sell your product online, you are selling it to your customers, and you cannot prevent your customers from selling it further to the other, people, friends or other third parties, provided that they remove the digital copy from their hardware, and the digital copy is used by someone else. It's quite interesting approach, very controversial. The issue is quite speculative, but actually the approach is positive because the commercial effects, of both models of distribution, the traditional one and the online one, the modern one, are more or less the same. Oh, I'm sorry. And now that's the part when I wanted to talk about the plot and the possibilities, of using the works of other people. If you are, creating something, a product, a video game, you can of course get inspired, but you can also create a dependent work. So actually, you can take a novel or a movie and make a video game out of it, and that would be a pure example of dependent work, and that would require the consent or license from the right holder of the original copyrightable work, the movie or the novel. But actually, there's such possibility of being just inspired legally without being requested or without necessity of obtaining the consent of the original right holder. That's the pure inspiration. So you can, for example, take the idea itself. The idea, one character, a very general one, and you can, based on this character, you can develop your own plot. And that will be the inspiration, which is, permissible from the legal point of view. You should consider to do that very, carefully, not to infringe the personal author's right. But actually, it is possible. So actually, if we would take the example of The Witcher, which is a very popular Polish game, so we've got an example of when the plot was used. Actually, that was not a dependent work, really, because the plot was a bit different. That was the sequel. The Witcher was telling the story which happened after the plot which ended in the novel. So actually, it is the further development of the events, which hasn't been, written by Sapkowski, but just invented by the people at CD Projekt.
So is it a dependent work, or no?
Well, that's the question. Whether how much of the plot they took from the original novel, and how much of it they invented themselves. I would tend to the opinion that actually that is rather the question of the personal author's rights and not the dependent work. So actually, they do not need the consent from the author for using the copyrights, but they do need the consent, So in fact, they do need agreement for using the personal author's rights, because it refers to the integrity of the work as such, because it is quite important, actually. The character of Geralt was very specific. It was not a general character. So we could argue that actually such character in itself is very creative, and say that actually every example, every situation in which you use this character, if you are not using the copyrights, that would be quite speculative, and I would say that actually they are not using copyrights. You are in each case you are interfering with this personal link of the author with his work, because it goes just too deep, and the character is just too strong. And anyway, an agreement with Andrzej Sapkowski was necessary anyway, and I think I'm 100% sure that actually there is one in place. So from the commercial point of view, it is just the same. They need the consent from the author, but not for the use of the copyright, but rather for the use of the personal rights, because they are just interfering with the integrity of the work. But we can imagine a situation when CD Projekt will be producing, the fourth part of The Witcher, because we're waiting for the fifth one, which will be the further sequel, if I'm not wrong, yeah. But let's imagine actually the CD Projekt is going to make, the next game, based on this idea, and they're going to make adaptation of the novels. So not the sequel, not the prequel, but just the adaptation of the story which is told in the books of Sapkowski, and that would be, in my opinion, a clear example of the dependent work, not the inspiration. And in this situation, when we've got the switchers which we have, the two ones, and we're waiting for the third, I would say that's example of the inspiration, rather, which goes very deep into personal author's rights, which interferes with the integrity of the work, and which needs to be authorized by the author. Well, game modding, that's also very interesting topic. I mean, game modding usually, in most of the situations, should be classified, as a creation of the dependent work. So it means that actually such activity would require the request of the original copyright holder. But it is important to stress that actually the creation itself is not infringement at all, not yet. You need the consent for the reproduction, for the sale, for making it available. So generally you can create, but you cannot make it available. Well, I think actually you could imagine, situations in which the game modding is very, the link between the original game and the game which is the result of the game modding is so loose. Is so limited that actually you could consider inspiration instead of dependent work. There's another term interesting, abandonware. The games of the video games of the people or companies which do not exist anymore because they went bankrupt and there is no copyright holder. It's the problem because you cannot use them usually because it's difficult to get any consent from the entity which does not exist. So that's quite absurd, That's an example of the orphan works. So even if you would like to have, pay a license to someone, you do not have the entity to pay. So actually that's a problem. But on the other hand, you do not have any risk, a big risk whatsoever, because if there is no copyright holder, who is going to sue you? Well, there is one entity which could sue you. This is the collective copyrights companies. But it depends on the legislation. Usually, they are not responsible for video games. They rather for the audiovisual works. So actually, it may vary from country to country. And well, maybe I'll talk a little bit about license. The instances in which you are creating a game and developing a game, and you would like to use third-party works. Then you need the consent. You need the license. The license agreement should include the description of the exploitation fields, which we already talked about. The territory. It is very common actually. The license are perpetual. That's the concept of the Anglo-Saxon law. That's the approach. It's very popular in Anglo-Saxon countries, for example, in the UK. But the point is that in Poland, the perpetual license is not possible as such. It can be only the 5 years. And then it turns into a license for indefinite period, which can be terminated regularly. So actually, it is not possible, at least under Polish law, to sell a license which is, perpetual and which cannot be terminated. That may be an issue for the open source license, which are perpetual. But if they would, if the open source license would be governed by the Polish law, that would be one issue, a very theoretical one, because in order to terminate, you need the other party. In case of an open source license, it will be difficult to identify the authors and the persons using the software. So. And well, virtual property. There is no concept. There is concept of virtual property, but it does not work, under Polish law. The virtual property as such does not exist. It's only being perceived by the users. It's an issue in case, of massive multiplayer online role-playing games, when the people are, buying certain items, selling them, whatever, you know, and someone, I don't know, steal the item from another. So actually there are many different possible situations which would require, I mean, appropriate classification. So actually, first of all, if there is no virtual property whatsoever, there is no sale as well, no transaction as well. So the question is how to understand it. I mean, how to perceive it from the legal point of view. If, for example, in one of the games, I mean, Diablo, you can sell the items, and that's the tool, I mean, the solution which is provided by the game developer, by the producer. So, and that's part of the game and a part of the rules which are relevant for all the users which are playing that game. And from the legal point of view, the item does not exist, but it's sort of a service, you know. It's sort of the service which the users are selling. So actually, if someone is selling a sword to someone else, you know, it's not selling an item, tangible one. It's not selling a software, but it's sort of a software service consisting, you know, in providing the other user with access code to the part of this software or whatever. So that is how it is perceived, you know, from the legal point of view. Also, if someone, you know, takes an item for someone else illegally, you know, and against the rules which are applicable to that game, it cannot be perceived as a theft from the criminal point of view. It is rather, you know, the special type of crime which is provided for, at least in Polish criminal legislation. And the other issue is, you know, the software. I mean, the game as a service. You know, usually the games used to be sold as a products, but they are more and more, I mean, being sold as a service. It means that actually it is one of the examples of the cloud computing, and it applies also to the games. So you do not need to sell the products. You just provide an access to the virtual world, and you are distributing your product as a service, which means that actually you are just dealing a bit differently with your customers. You are just not providing the video games in a package, you know, on a digital medium or tangible, whatever. But you are just providing an access to the virtual world, to the internet platforms when the users can play the game. And it means that actually the producers of the video games are becoming not the sellers, but just the internet service providers. And it means that actually there's a specific law regime applicable to such internet service providers. They need to, you know, provide for terms and conditions. You know, that's quite a challenge, because there is an issue with the unfair clauses, which cannot, you know, violate. I mean, the clauses of the terms and conditions may not violate the consumer rights. If they do, they are regarded as unfair clauses, and that's a real issue for the entrepreneur. There is also an issue related to the user-generated content. I mean, many games are really interactive. So actually, the users are providing a lot of, you know, content, and that content may be illegal. And then the question appears: who is liable for the infringement? If the user provided some content to infringe the copyrights of someone else, you can of course sue the user, who is the first person who violated the rights. But what about the status of the game developer, being in that example, I mean, the internet service providers? Is he really, I mean, liable also for the content of the user? And the question is, and the answer is actually that he is, well, under circumstances he is not liable, but at the moment when he learns about the illegality of the content provided by the user, he is also liable. So in that case, I mean, both the user and the internet service provider is liable. If we would, I mean, come to the conclusion that a user playing a game provided a content, I don't know, in terms, you know, of a chat, that is, well, possible. Actually, the tool of a chat is quite popular, I guess, in video games, and someone has, you know, violated our personal rights in terms that actually someone said on the chat that we are stupid or whatever. That's an example of defamation. Actually, that would be the user who will be liable for that. and that could be also the provider of the platform who could be liable, provided that we would need to make use the procedure called notice and take down procedure. We would need to require the internet service provider to take down this illegal content, and if he would fail to do so, he will become liable. That will be the prerequisite of his liability for the content of the user.
Excuse me, I've got like 7 minutes more.
7 minutes. Well, I guess that will be it. I mean, there are also other issues. I mean, the consumer protection would be a huge topic in terms, of the video games, because I mean it's always a B2C product. So it means that actually I started with the copyright. It is very important, because that's the very fundamental thing. It's good to know how the product you created is protected from the legal point of view. But the other issue now is your relationship with the customer, which in this situation will always be consumer. That means that actually you need to comply with all the legal framework applying to the protection of the consumer, and there are many unsolved issues which may be challenging for entrepreneurs. Notification obligations is not a problem. You need to notify users of many rights they have in relations with you. But distance selling is interesting. I mean, if you are selling a game online, then the user has a right to withdraw from the contract within 10 days. And there are exemptions from that right. If you are selling a CD and you are sending it as a tangible copy, then the user may not withdraw from the contract if he opened the box. I mean, opened the CD. That's how it works in this traditional way. So actually, if you are buying a CD and you bought it online, but it was delivered as a tangible copy, you look at the CD, you don't open the package, and you decide, okay, I'm going to withdraw with 10 days. So you are sending it back to the seller. But if you are open it, you lose your rights to withdraw. That's only logical, because otherwise it wouldn't make sense. Because if you open CD, okay, there are some technical measures to prevent that, but actually usually it could be copied. So that's the reasoning behind such solution. And the problem is that actually if you are selling something online, as a game, for example, and the user is downloading it, then from the legal point of view, he's also, authorized to withdraw from the contract within 10 days. It's absurd, but that's how it works, And well, the lawyers are trying to find a solution and justify, a different interpretation of the law, but it isn't working really, and the law will change. There is already a draft of a new law which is solving this issue. Another issue are the payments. If you are dealing with the consumer needs to have an option to pay for the product at least simultaneously with the delivery of the product. It means actually it is forbidden to require the payment for the product first. So in practice of the online stores, it works like that. Actually, you've got many types of the methods of payments available for the consumer, and one of them, I'm not sure how to put it in English, is the płatność za pobranie, which is the payment being made at the delivery of the product, collected by the postman, or the courier. And this is, this option is just provided because of this legal requirement. The consumer needs to have an option to pay at least at the moment when he delivers a product. So he cannot be required to pay prior to the delivery. And if you are dealing, if you are selling your products online, that's a quite, complicated, and that's quite, practical problem. How to solve this? You could argue that actually such method payments like PayPal, are at least simultaneous. And actually, they're happening simultaneously. You are paying, and you are receiving the product at the same time. But from the practical point of view, the payment is done first. So actually, the consumer is paying first. The entrepreneur is verifying the payment, and then comes the products, and that is forbidden by law. And that's one of the practical problems with consumers. So I guess that's all of it.
Thank you questions? Got like 15 minutes more to. No one? I've got one question. No one? So I'd like to.
I failed. I mean, apparently.
Okay, please.
Yeah. So I had a case when I have a soundtrack which I use it in the game, and I'm trying to use it in marketing materials. And I put in a license agreement with a musician that we're gonna use it in all fields of usage. But is it actually another field of usage? Just the dependent law on the game itself? Does it make any difference from the legal perspective? So do I have right to use it in this particular soundtrack in a different games or in the movies or in other materials?
You know, I mean, the exploitation fields is understood as a source of, as a method of monetization of products. So actually, if there is a certain, you know, field on which you can make money, you know, I mean, in terms, you know, of using something to make money, that is the definition of exploitation field. And one of the, I mean, classical example of the new exploitation fields are the ring bells, you know, because prior to the mobile phones era, you know, there was no ring bells, you know, and once someone invented the mobiles, you know, and they became popular, a new exploitation field appeared, you know, that was the ring bells, because that was the new source of money for the authors. And in your example, I wouldn't say that actually it is not covered, you know, by the exploitation fields, but it's crucial to decide, I mean, what was the wording of the agreement? Because if you only refer to all the exploitation fields, then you probably have a problem due to the fact that actually some of the authors claim that it's not sufficient. You need to list all the exploitation fields which are agreed by the parties. Usually parties just repeat the wording from the act. I mean, there are 4 types of the exploitation fields: reproduction, you know, making it available, rental, and so on, and then add the specific one which they need, just to be sure, to make sure that they have all, you know. And you just need to look into your agreement, license agreement with the musician, and see whether you have applied this approach. If not, you know, the issue is speculative. I would say if you said in the agreement all the exploitation field, I would argue that actually it covers everything. What is said in the act? I mean, the Polish Copyrightable Act. It is, you know, quite controversial argument, but nevertheless may work. So I would stick to the opinion that actually there is no new exploitation field. You have both the right to use this music to all the exploitation fields existing at this point of time where the parties signed the contract. So you are entitled, authorized to use it. I mean, the most of that was the intent of the parties, really, you know. They maybe failed to make it specific and very precise in the agreement, but actually the understanding between the parties was that actually you are buying everything, you know, and for all the purposes you may use this music for all the purposes possible. So that, I would say that, well, the issue is not quite clear, but not hopeless either.
May I have another one?
Yeah, of course, because you are on.
We are doing products for Americans, and we are doing educational apps. And I saw lots of other companies which do the disclaimers saying that, for example, if we say that we teach somebody math or teach somebody reading, we don't really mean that we teach them, but we are trying to do it. So, and lots of disclaimers says that we are doing our best to teach you all totally to read, but we cannot guarantee the results, etc. I was wondering what's the reason behind this kind of disclaimers, and can I be sued because of the promise that I will teach some skills without having a proven example that it really works?
Is it a license agreement?
No, it's been called like disclaimer notice.
And when
It's not in a license agreement, it's a separate, I don't know, separate paper, separate document. It's part, I believe it's part of the license agreement, but it's done on a separate.
But it's certainly on a document which you are signing.
You don't sign anything, just buy an app from the App Store. But
I don't quite get the issue.
We have, let me give the example to be precise. We have an app, and it says, I will teach your kids to count from 1 to 10.
Okay.
And we have a license agreement which puts all of the points which are required in the license agreement. We won't, take your date outside.
So you are selling the app and you are giving the license to someone else?
Yes.
Okay.
And within the license, should we put a disclaimer that we won't teach your kid to count to 10 for sure, but we just do our best to do so?
Well, the first question would be whether this license agreement is governed by the Polish law.
No, it's by the program.
So that's not the question to me. No, I wouldn't expect this proviso to be necessary. I mean, this disclaimer to be necessary. Because that's the license agreement. So.
So why is it happening that all of these companies put it there? So I'm just worried that it might be a case in the future.
That may be that's the American approach to the safety products. I mean, you need to put all the possible disclaimers. That actually the hot water may be hot. And so on, because I mean their approach is a bit different than the European one. And if you don't put this disclaimer, I don't know. I'm not an American lawyer, but well, they're a bit crazy about it. And I would assume that actually that's the reason for which they, have to have such disclaimer in the agreement. But usually, if I would draft this agreement, and it will be governed by the Polish law, I wouldn't see any necessity of having such disclaimer in the agreement, But if you are, granting a license, and you are adding disclaimers, so well, the greater number of the disclaimers, the better for you, because it limits your liabilities. So.
So, is there any possibility that I will be sued because of lack of such?
No, because I mean the idea of the disclaimer is to limit someone's liability, and that would be situation.
I don't have one.
Yeah.
Because I don't have it.
Just I mean, out of the fact that you are granting a license, someone would require you to teach his or her children to count from 1 to 10. No, I don't think so. That wouldn't, work under Polish law.
I think it's not the question of the copyright law, but the consumer protection, I guess. It's something like with, I don't know, medicine, and you tell that it will work, and the consumer has the, I don't know, walking.
I know. Yeah, I know, but but.
I think it's a different area, not the copyright law, but in Poland.
Okay, in Poland it is the safety, which is the issue now. So actually you need to provide all the necessary notification regarding the safety and the usage, and that could be an issue, potentially also under Polish law, if you would, make it, part of your business model, saying that you will just misleading the people, saying, I mean, if you buy this license, this software, this app, your kids, be doing, high school within, I don't know, 3 years, although they are 5 years old, and that would be, misleading, and that could be a problem in terms of UOKiK and other Polish authorities, because that would be, act of unfair competition, and act which would violate also the collective interest of consumers. So, but only then if that would be made as within willful misconduct, that you would do it on this purpose, to make people believe that actually if they buy your product, they will achieve, I mean, the results. So you would have to, on purpose, generate such expectation of the clients and instigate them, to buy the product. Then in such situation that could be an issue, a legal one, also from the perspective of the Polish law.
In other terms, I need to contact a lawyer in the States in order to make sure that I am not doing any crime. You're right?
Yeah, I mean, if the agreement is governed by the law of any state of United States, then absolutely, I mean, the investment in lawyer is not a luxury. I mean, it is perceived, as a luxury for many entrepreneurs, middle entrepreneurs. I mean, they don't need a lawyer because, it's too expensive and so on. But the point is actually that may work, until some for a while. No? But when the shit happens, then actually it turns out that actually that lawyer at the beginning could be much cheaper, than the involvement of the lawyer. I mean, at the later stage. So it's always, the risk assessment. So.
Okay, thank you. Any more questions? I would like to ask you about the inspiration process. For example, when I look at the Angry Birds app and I prepare the same kind of app, changing the characters, would that be an infringement?
Changing what?
Characters.
Oh, yeah.
Like angry flowers or something like that. But the app will work exactly like Angry Birds.
And what about the graphics?
I will change that. I'll just sketch my own graphics, change the characters, but the app will work exactly like Angry Birds. Would that be an infringement? Because it's a kind of an idea for the game, for how the game works, right? And I just took it. I changed characters and I sketched my own graphics.
I know. Yeah, and yeah, that's quite common approach, and many entrepreneurs are trying to be successful at such attempts, and it would be hard to argue. I mean, it would be hard to demonstrate a copyright infringement. Maybe the infringement of personal authors' rights. I'm not so sure, but that would be an act of unfair competition. So we would have another type of infringement of rights. So actually, that would be an example of trying to misuse the success of another entrepreneur, of your competitor, trying to pretend that actually you are, maybe selling a game from the one family of the games, and if the consumer would be misled, as to the origin of the game, that would be rather an example of unfair competition. And I mean, copyright infringement would be hard to justify in this scenario.
Yeah, because if there's it's more of a genre of a game, tower defense. You have 1,000 games of tower defense. They're all the same, and none of them are infringing unless they are. But then
that would be the problem if that would. I mean the potential lawsuit. I mean the plaintiff would have to demonstrate that the people are misled. That they're buying your product, thinking that they're buying my product.
It's consumer.
Yeah.
It's consumer law. It's not copyright law.
Yeah. Absolutely.
Some questions? If no, thank you very much once again.